Welcome, everybody. This is Amateur Radio and the Law. We've got 4 speakers. Each one of us is a lawyer, so that means that you get a chance to attack during the question and answer session. I'm Fed Hopengarten, K1VR. I'm moderator for the session. The first speaker is going to be the West Gulf Director, John Stratton, N5AUS, followed by David Siddall, K3ZJ, the ARRL's Special Counsel for FCC Matters and a former FCC employee. And the third man to speak will be Barney Scholl, K3LA from Western Pennsylvania. He's going to be talking about estate planning matters, what to do with your gear when you are no longer able to call CQ on 75. And I'll finish up with some comments on the latest in antenna zoning news. So I'm going to begin with John Stratton, N5AUS.
To be fair, as lawyers, we need to warn you. Everyone who's talking to you is a lawyer. You notice when you came in, it was free. But with lawyers, there'll be a charge when you leave. So pay attention. The question is, why would the National Association for Amateur Radio spend its time and your money lobbying Congress? It's because Congress and its 535 members have the ability and the power to intentionally or unintentionally pass legislation that harms amateur radio. But it can also pass legislation that benefits us. An example of unintentional harm is the Agricultural Improvement Act of 2018, also known as the Farm Bill. How can a farm bill hurt amateur radio? Because hidden within that bill was a congressional mandate to the United States Forest Service about recovering cost. In order to comply with the mandate, the United States Forest Service issued a notice of proposed rulemaking in December of last year. It's proposed in this notice of proposed rulemaking to impose an annual, one-size-fits-all, $1,400 fee on every communications user within a national forest. If that rule becomes effective against amateur radio, based upon our research and feedback from the field, it means almost every amateur radio repeater location in a national forest will, because of cost, have to cease to exist. But what Congress can do, Congress can undo. Now, we filed comments, David Siddall filed comments opposing the imposition of that fee on amateur radio. But because it's a federal agency and we can't really trust them to do what we want, we have contacted the Senate committee that has oversight over the Agriculture Department and United States Forest Service. As a result of our efforts, our lobbyist efforts, and of the effort of members of the league in these districts, the senator who is the chairwoman of the committee, Senator Lou out of Michigan, and Senator Lujan out of New Mexico, and the ranking Republican member, Senator Bozeman, have all three, on our behalf, believing that amateur radio is important to their states, contacted the Forest Service and expressing a clear wish from the Senate committee that the Forest Service not implement the fee on amateur radio. Senators usually are pretty influential, but in case the Forest Service is not persuaded, we already have in the works the preparation of a bill that will be filed separately from this committee that will be an order from Congress to eliminate the fees if imposed on amateur radio. So it's belt and suspenders. We get one or we get the other. But Congress can do something else. It can order the FCC to take actions that will harm amateur radio. And as we all know, we exist to a great extent at the pleasure of the FCC. An example of what Congress can do in directing the FCC that can cause harm is the, we think, inappropriately named Spectrum Innovation Act of 2021, also known as House Resolution 5378, introduced by Representative Doyle out of Pennsylvania. When the bill passes, and we think it will pass, it will be a congressional order to the FCC to sell 3.1 to 3.45 to 5G users. The result of that is that we will no longer have secondary status on 3.1 to 3.45. With our Washington counsel, David Siddall, with our lobbyists and the lobbying team, we have approached Representative Doyle and his committee, and we're working with them to amend that bill. The amendment would order the FCC to leave us as secondary users of 3.1 to 3.45 even after they sell the frequencies. If we don't know whether that will work because the committee is still working on the bill, but we are trying to get that amendment through. But the league is not just doing defense on your behalf. It's not just trying to defeat bad bills. The primary legislative effort that is ongoing and has been for the past 3 years is a passage of a bill, a law, that when passed will eliminate all private land use restrictions on amateur radio that are imposed by our friendly homeowners associations. Now, you all know what a homeowner association is, don't you? When this bill passes, it will eliminate any restrictions on the erection of amateur radio antennas in residential property. Now, if you aren't familiar with legislative efforts, most people think that the passage or defeat of legislation is a result of either magic or mysticism, but it's not. It's a result of diligent hard work, not just by us at the league, by our lobbyists who aren't here, or even by you. It takes the work of a team to make this work. It's what Fred, when he stands up, will tell you is known as just basic blocking and tackling. It's what Woody Hayes used to call 3 yards in a cloud of dust. That diligent work can result, if we have the help of everyone in the field, in the passage of legislation or the defeat of bad legislation. It can be done. Now, the members of the legislative committee currently for the league are Fed Hopengarten, Tom Abernathy, who's not here, Lee Cooper. Lee, are you here? No, Lee's out getting something to eat, I think. When we're through, if you have any questions about what we're doing or ought to be doing, raise your hand and ask questions. Fred, who do you want next? David?
No. How many lawyers does it take to plug a USB drive in?
Which one is you, David? Is that you?
Try it. I don't know what it was called. It's a Dayton presentation. I can send it to you. I don't know if you renamed it.
I didn't.
Oh, wait a minute. I see.
How do you open it?
Get rid of this.
Should we go to PowerPoint first?
No, because get out of it.
These are,
Now go to the drive. You'll see, execute that. Now you'll see File Explorer. Execute that. Give it a second. It's a slow machine. And then look for the USB drive.
it's got, David, do you remember the name of yours? Is this you? No, that's Congress. Is this 590, Hamvention presentation?
Give it a second, but please. Where's the second? Can't read. Okay. Is that what?
None of them ring a bell with me. I can finish. I didn't.
Try another one, see if it boots, just to make sure it's working. Okay, just execute another file. One of those. It may be an old. Do you have old PowerPoint?
That's me, right
yeah,
there.
that works fine.
But it was him.
Okay. We'll go back and find his.
Did you try it before?
I didn't try yours.
Yeah, try whatever. I wasn't trying it.
That's him.
It's four there, so
Gotta find the file first.
Dayton speech?
try that.
Did we try that
That's the
already?
one you did.
That's the one I did already?
Let it boot. Give it a moment. Now, if that's yours, it's a bad file, or you have a very old copy of PowerPoint. Try one of the other ones.
It could have been an old file. I thought you were.
Okay, go get a USB stick and John will boot it up on something else. Barney?
If you don't have mine, I'll just talk.
Okay. What's you, are you presentation? Is that you?
Do you have your mail on this? You could just look
No,
at
this
your
is
mail and open
this is the convention computer. Thumb drive's right there, but we're not
Are
finding
you on the thumb drive?
File Explorer.
Make sure you're on the thumb drive. Yeah, you should be on. You're not in your drive.
Oh, there's the drive right there. Dayton. All right. So. All right. There you go.
Is that billable time?
Pro bono. Slideshow.
Hey, look at that. Thank you. I guess the problem is we're using a Hamvention computer, so you couldn't check it. I'm Dave Siddall, K3ZJ. As Fred has said, I represent the ARRL at the FCC. I actually look at it a little differently than most people because for 13 years of my life, I was the FCC person on the other side of the table when people came in and wanted this, that, or the other thing. And I did it at all three basic levels of the FCC. I went in as a senior attorney. I was in charge of several proceedings, one of which you probably know of, It was a proceeding that allowed digital high-definition TV to be implemented in the United States. When we started, we weren't sure whether we should do that or not. And so I headed the staff for 3 or 4 years, from the beginning until it was well into implementation. Then I took a job as chief of the spectrum management branch. So I had oversight of any change in spectrum allocations, either U.S. or international. And we had a staff, of course, that worked on the international spectrum management. And then I actually took a legal job, legal advisor to a commissioner, and there I was responsible for all Wireless Bureau, Office of Engineering Technology, and some of the Media Bureau items. Each commissioner has several advisors, and they're responsible for reading each of the items that are at the commissioner level, in other words, the really important things, and then they work out how the commissioner will vote or what changes should be made. Now let's see if I can figure out how to change this. Hey, look at that. Now, Fred always has a picture of his book. So I felt, this is the Fred slide. I also wrote a book back, I was in a communications group at a law firm right after leaving the FCC, and we were asked by Telecommunications Reports to write a book about how to navigate the FCC, and we ended up calling it FCC Lobby. The reason for that is TR Reports is, you may know of this, Fred, they're printed on yellow paper, and every day you get a summary of what's happened with telecommunications law. They started doing this in 1934 when the FCC was formed, and they're still doing it today. It's electronic today. And they came to us and said, you know, we get these requests like what's going on at the FCC, and people are asking how to navigate it. So we did the book for them under contract. I actually looked today to see if there's anywhere you can find one, and I found a used copy on eBay. So it's still circulating. I was told at one point that the biggest purchasers were other law firms. In other words, the competitors to where I worked. But it did cause me to go through how to work at the FCC right after I left. I did work on Capitol Hill for 12 or 13 years before going to the FCC. I mouthed off at a meeting one time, and afterwards the chairman of the FCC was in the meeting and said, hey, who's that guy? Would he be interested in working for us? We need a bright guy or something. I wasn't sure if he thought I was bright or whether he just wanted to get rid of me because I was causing problems with some of the senators. And so I've done a number of things like that. This is the I'm sorry? Oh, that's right. This is the context, and I've highlighted the places where you can submit comments, and the public comments are listened to and read. If there's a petition, there will be a time for public comment, or you could submit a petition, and if the FCC accepts it, they'll put it out for public comment. It can lead to two things. There can be a notice of inquiry. A notice of inquiry is when the FCC believes it's going to want to make a change, but it hasn't decided what to do. So instead of saying we propose to do this, they put out a notice of inquiry. They accept public comment for people to say, well, yes, you do have a problem, or no, you don't. And if you do have a problem, how should you change it? Now, if the commission knows what it wants to propose, that's a notice of proposed rulemaking. And again, there's a public comment period for notices of proposed rulemaking. That's where the FCC says we have a problem, this is how we think we should fix it. They give us an opportunity to say yes, no, or amend your suggestion in some other way. That ends up in a report and order. That's when the actual change to the rule is implemented. And if you don't like it, you can ask for reconsideration. And if you ask for reconsideration, there is a comment period on that also. So these are all places where you can comment. The question comes up, how do you submit comments? And I'm going to get to what should be in your comments to be effective. And that's about what I can get to in 5 minutes. You go to the FCC website, fcc.gov, and that's right there on the front page. All you do is click on it. And you come to this page, you get a choice on whether you want to submit formal comments or whether you just want to submit a paragraph or two, a quick comment. Either way, you come to a page that looks like this and you type in the information. This is where it's amazing to me how many people make mistakes. There was one proceeding where we have 40 to 50 people who have claimed to submit comments, for example, by the ARRL. I don't know why they would ever write ARL on these pages. They're really quite simple. Your name, address, email address, and the email is suppressed, so the public will not see your email address. The FCC has it in case for some reason your file was corrupted or there was some other problem. They know how to get a hold of you to correct it. And then if you're submitting something written on a separate piece of paper, this is where you simply click to bring up your document and send it to the FCC. If you've said you want to make a quick comment or express comment, there's a box here where you can type in directly what your comment is, and then you hit submit. The key is to make effective comments, and I would just have a couple things to say about this. Always refer to what proceeding you're commenting on. Again, you might be a little surprised that there's people who submit, and you can't quite figure out what they think they're talking about. And I've been on the other end of that. So always state the document number. Minimize telling the FCC what it itself already has said. The person reading your comment most usually is the same person who wrote the FCC document. They know what they said. You don't have to repeat it all to them. At most, one sentence saying, I'm commenting on X, Y, or Z. I think what I'm trying to say there, if you're addressing multiple comments, do it in the order that the FCC addressed them in their proposed rulemaking. It makes it a lot easier, because what the staff has to do is correlate what you're saying with something that is a proposal in their docket. If there's multiple issues, it's a lot easier to do it if you've used the same order that they use. Concentrate on your main points. Make sure you have a main point. Don't put in 3, 4, 5 paragraphs and somebody will be scratching their head. Well, I wonder what they're commenting on, or I wonder what they said. And I've seen all this in my life. It's more common than people would like to admit. Use the FCC choice of word. If the subject is vanity call signs, don't start calling them special call signs or special assigned call signs. Use the FCC nomenclature. Then they're sure to know you're commenting on vanity call signs. They might wonder, what's a special call sign? Do they mean vanity? Do they mean one of our other types of call signs? A good, brief, clear comment can be 3 paragraphs or less. That would be the express comment if you wanted to do it. If you do go beyond 3 paragraphs, be sure to put in a couple sentences up top summarizing your points, and then go into your points. Makes it a lot easier, again, for the reader to know what you're talking about. Give reasons for your view. Lots of comments just say, I think you shouldn't do this, or I think you should do this, or you should get a life and not be involved in ham radio, whatever. Always put reasons on why you're suggesting this or that. It makes it much more effective. If you're using an organization, sometimes organizations, including ARRL, will send something out and say, hey, we really would like people to comment for or against this proposal. You could take the ARRL comments and just resubmit them. It's a lot more effective if you pick something out and you say, I think ARRL is right on this because, or heaven forbid, if you're on the other side, I think ARRL is wrong on this, and here's why I think they're wrong. Or this is why the FCC is right or wrong. But give reasons for what you're saying, not just conclusions. And if you have some particular expertise or experience, do tell them. That's where they don't repeat. Some people get confused. When you submit a comment, there is a delay up to 24 hours because before it shows up on the website. And so don't keep submitting the same comment. 5 days later, don't decide you should have changed this word to that, so you edit it and resubmit it. Unless it's really, really bad or you've made a basic mistake, just let it sit there and speak for your comments. Otherwise, they don't know which version that you submitted should really be the one they're reading. You can certainly, there is always an opportunity where there's a comment opportunity, there's always a reply comment opportunity. If you decide there's something more to say, say that. They have deadlines, usually 30, 45 days after publication in the Federal Register. The ARRL is pretty good at putting this in their news items. But here's the thing a lot of people don't know. They will take your comment even outside of the deadlines. So if you wake up 3 months later and they haven't ruled yet, you can always submit a comment. If they haven't done their work and have already made their decisions, they will take it into consideration. If they already have a decision navigating the FCC bureaucratic structure, they won't. That's their option. Most normally, they will take into account what you have submitted up to nearly the last minute. They don't announce this. They don't tell anybody. It's simply something that the Commission has come to do based upon we want every fact that we can, and if somebody only submits it late, that doesn't mean that it isn't valid. And they certainly have the legal authority to do so. It's one of the few places. Courts won't do this, of course. Many other agencies won't, but the FCC, it's gone a different way, and that's sort of tradition. It's not a legal requirement. It is a tradition, and I haven't known it to be changed by any of the different political changes. If you talk to the FCC staff, be sure you file a letter in the docket saying who you talked with and what you discussed. You can call and ask, are you about to rule? I make all sorts of calls that are not substantive. They're, hey, this is pending. Do you think this would be, are you working on this in the next couple of months? Are we about to see a report and order? What's going on? That's simply a status request. If I go over the line, going over the line would say, well, you know, my client ARRL is totally against this, so I hope you're not doing it. Are you about to do it? Then I have to file a letter saying I talked to a staffer, who they were, and what I said. That's just something. And I thought we were going to have questions, but I'm told there's going to be plenty of time for questions after we're all done. Thank you very much.
Good afternoon. Get used to the microphone. I'm Barney Scholl, K3LA, and I'm not going to talk about how to get your tower up in the air, your antenna up in the air, but the other side of the coin is that something that I've been dealing with throughout my practice is estate planning, which sounds like a boring topic, but most of my experience comes not from, really from experience of what I've run into in other people. Amateur radio is, the problems that exist in amateur radio are not unique to amateur radio. I've run into it with, I have one that I'm still dealing with. Someone had a railroad collection of memorabilia, and that estate has been going on for 5 years just to get that stuff cleaned up and sold and taken care of. Anytime you have a collection of things, one of the examples that I researched for was plows. Another one was, again, railroad memorabilia. Anything with a collection can cause problems. I thought I would, the 2 points I want everyone to remember when I'm done is the 2 things that are best things to do is to clean out and organize your amateur radio equipment. Those are the 2 things that will make the most difference to your family and those around you when, I guess, when something happens to you or us. It's bound to happen to all of us, obviously. Before I even talk about things specific to amateur radio, things that we should all recognize and address are having a general power of attorney, or a durable power of attorney you may hear it called, a will or a trust, and often, especially if you end up in a hospital, they'll ask you if you have a living will or a healthcare power of attorney. These are not unique to amateur radio, as I said. And the other comment that I often say is it is cheaper to pay an attorney to do this type of material. It saves you money down the road. It's like change the oil in your car. Do you want to change the oil in your car or buy a new engine? This type of work is much easier to do ahead of time than it is trying to solve problems afterwards. When someone passes away with an amateur radio collection, obviously you have to donate the equipment. Probably the most expensive part is dismantling or taking down towers. It might be pretty simple if you have a wire dipole with an open wire feeder. But on the other hand, if you have multiple towers, a good friend of mine has 2 towers over 200 feet, plus several other towers, can imagine what the cost is of taking it down. I myself have a self-supporting 70-foot tower. I asked a friend what would he charge to come in and take it down. It was in the thousands of dollars, unless it's something old and they cut it off and let it fall on the ground. But still, there's a cost to cleaning that up. You should notify the FCC that you have passed away. And then the question is, does your family have the knowledge to do this? If you're the only one in the family with a license, you may be leaving a burden on your wife or children. And clearly it depends on how much stuff you have. I could ask how many people lived in the same house for more than about 10 years. I've run into people who lived in homes for 30 and 40 years. You can imagine how much stuff they have in their house. And there are a lot of solutions to that. They don't always provide the best answer. Some of the challenges, if just the equipment itself, obviously, if money is concerned, you want to maximize the value for it, either whether you're selling it or getting a larger donation for it. Again, limited market. I'm thinking, I'll even use myself as personal examples. While my mother was alive, I used to buy her a Christmas plate every year. I now have 25 Christmas plates in my kitchen, and I really don't know what to do with them. And my wife is probably thinking to herself as I say that. But some of the solutions, auctions, flea markets, eBay, are all possible solutions. Generally, when you go with auctions and flea markets, a lot of times the cost is a percentage, so it doesn't cost a lot to get rid of equipment. It's just a matter of how much you get for the equipment. As I said, I believe that towers, antennas, cables, and other built-in parts of your home are another matter that has to be dealt with. And the cost can be much greater than selling equipment. It all depends on, as I said, how much you have up in the air, how long it's been up there. I recently took down my tower that had been up for 14 years and redoing it, and if it were up any longer, someone might say, take it down, just cut it over and let it fall over. Solutions, you have volunteers, your local club. If you want to take down towers safely, I was listening to part of the forum next door about antenna or climbing safety and what it costs to get certified as a climber. And do you want your friends, buddies climbing tower unsafely to take stuff down? Probably not. Other solutions, Ryan volunteer friends. There is one that I've come across, a website called hamestates.com. And I can't recommend them or say anything about them. I did read how they work. And how they work, you pay a monthly or yearly fee up front while you're alive. When you pass away, they come in and basically evaluate your equipment. I guess they will even clean it up. They'll decide what to do to take down your towers, clean out your house, and then they take a percentage. I think it was 30, don't hold me to the 30%, maybe it's 20% of whatever the net value they get from everything they've cleaned out. It's Ham Estates. One of my last slides, I have a list of all the things I did for resources, and I have this presentation on my website, and I have that address at the end. So you can look at this, my references later on also. I was able to spend a little bit of time talking or listening to a discussion about someone was even in a rather very large station, and that part of the discussion was, what do we do? How do we keep the station intact after the person dies? And that would even be a bigger project involving trusts and things like that. But if you have enough of the equipment, that might be sort of a off-the-wall solution. This is the resources I used with links to them. You'll see the one for the first one at the top. Hamestate.com is the one that is the commercial organization that will do it. That will do that for you. Again, my presentation is on the website, on my website. Again, I'll end with what I tried to start with: clean out and organize. And the other comment is, you're not doing this for yourself, you're doing it for your family and children. That is why you should pay attention to this. I knew very well in 5 minutes or so, I couldn't say a whole lot, but my goal was to make you aware of some of the issues and make you think about it down the road. Excuse me? That's where I have this presentation. My website /Dayton underlined 220.22. It's up there now. I checked it before I got here and it works. Thank you.
Thanks, Barney. That's scholl.org/Dayton _ 2022. Open. I'm fine. Slideshow from beginning. I'm Fed Hopengarten, K1VR, and I'm the author of the ARRL book on antenna zoning. So I talk about this topic a lot, and I'm glad to talk to you after. And for people who want, I'll meet you out in the hallways, because we don't want to interfere with the next forum coming along. I do want to take just a second to encourage you to join the ARRL. I've been a member myself since 1956 and serve as a volunteer counsel. And I also do donate to the Diamond Club, and I urge you people to think about such a thing as well. I just wanted you to absorb this concept. Over the summer, I created a 6-part webinar on the whole antenna zoning process, which you can find on the ARRL webpage. And that's 22 minutes on each of 6 topics on the process of getting a permit, which would obviously be more detailed and free, more detailed than I can possibly get into today. So I do think that you might want to consider going to the ARRL website. You'll notice in very small print, there's a URL right here. If anybody wants this URL or any other URL from my presentation, just send me an email, k1vr@arrl.org, k1vr@arrl.net, hopengarten@post.harvard.edu. I'll be happy to send you this presentation. Just to tell you a little bit about one of the things that's happened recently, K9CT, who's here at Dayton Hamvention, wanted to put up some more antennas at his 10 acres in Peoria County, Illinois, where the zoning ordinance is a maximum of 36 feet unless you are granted a variance. Personally, I thought that the ordinance was illegal because it's a firm fixed maximum height, and there are cases in 7 circuits that say that's an illegal type of ordinance. So we started off with me sending a stern letter to the county, citing the circuits and the courts and the states with a total of 7 federal circuits, stating that a firm fixed maximum height is illegal even when a variance procedure is available. And what happened was that basically we scared the county enough so that they granted a variance instead of going to court. I thought going to court would be more fun, but nonetheless, they did grant the variance. Is anybody here from Illinois? Okay, then I want to talk to you because there's an oddity in the state of Illinois. There's an equivalent of PRB1 for Illinois, and it only applies to cities and towns. And if you live in an unincorporated or you live out in the county, it does not apply to you. This is totally crazy. And the people of the Hams of Illinois should organize and get that statute extended to cover the county government as well. And you'll see the citation here for the portion which does cover municipalities but does not regulate counties. Another recent case, because this is antenna zoning news, is there was a case in Framingham, Massachusetts. Anybody here from Massachusetts? Good. So maybe you heard about this Framingham case? Yeah, you did. Okay. This is a guy who's a Russian emigre who settled in Framingham, Massachusetts, wanted to put up an 80-foot tower. Part of the zoning bylaw said that he can do that and the setback is 15 feet. Part of the zoning bylaw deals with cellular telephone and says that amateur radio is exempt from the cellular telephone portion of the zoning bylaw. And the neighbors were all excited, and despite what I thought was a very good presentation on the law, the zoning board decided against the radio ham on this appeal from the building inspector who had actually granted the permit, and we had to go to court. Sadly, we had to go to court. But I will tell you that the outcome was favorable to the radio amateur, and what I want to clue you in on generally is the Telecommunications Act of 1996 was written to accommodate the advent of cellular telephone. So you'll find throughout the United States a lot of zoning bylaws that were written in 1996 or 1997 to accommodate cellular telephone. Sometimes they were well written, sometimes they were badly written. But you have to make sure that you figured out what actually applies to amateur radio since 1996, because you don't know until you actually read it, and don't trust anyone's word on it. Don't listen to the very sweet and kind person at the counter. Don't listen to the building inspector necessarily. Read it yourself. And when there is a conflict between a general bylaw and a specific bylaw that deals with amateur radio, just remember that the specific always rules over the general. This is important because I've run into these kinds of situations 2 years ago in Newton, Massachusetts, and I would comment that here in the audience is K3AIR, who's an attorney in Pennsylvania and has found this argument to be successfully used in Pennsylvania. Hold up your hand again, Mike. Mike is a Pennsylvania attorney who does handle zoning cases, and he has successfully let people understand the difference between cellular telephone and amateur radio in Pennsylvania. Sometimes you'll run into an interesting bylaw written like this that, well, I'll read it out loud. The wireless communications commitment shall be installed in compliance with all applicable federal and state laws, including but not limited to the radio frequency emissions regulations issued pursuant to the Telecommunications Act of '96. Basically, that portion says that the zoning board cannot consider RF emissions in the decisions about a cellular telephone tower. But it only applies to applications under the Telecommunications Act of '96, which is cellular telephone, not amateur radio. Don't get tripped up by trying to claim that you are exempt because cellular telephone is exempt. Not true. Another thing I would tell you is that there was a very good decision for amateur radio a couple of years ago, the very first decision where a court held that the fees that were being charged to the radio amateur were excessive. This was a situation where the guy was putting up a used tower that he'd used elsewhere and an antenna which the court valued at about $1,000, and the town started out trying to charge $17,400 in consulting fees just to process the application. Eventually, the town got wind of the applicable law, and they reduced it to $58.74 plus a $1,000 escrow, meaning that more could be charged later. And the blessing is that the court decided that that was excessive, and the citation to the New York State reporter is included here. And again, if you ask me later, I'll be happy to, by email, I'll be happy to send you a copy of this presentation with the URL. On the homeowner association side of the world, I would tell you that there has been a big breakthrough in, I think it was in 2019, as far as I know. There are about 10,000 residents of Sun City Grand in Nevada. And they had some activist hams who got together with their club, and they negotiated antenna design guidelines. Under the rules of the Homeowner Association, amateur radio antennas would have been illegal anyway, but they managed to work something out. And this is what they worked out. Maximum of 2 antennas. Putting it on the roof is okay, but it had to be, quote, as hidden as possible, unquote, and not more than 5 feet above the roof peak. If it was mounted on the ground, it had to be hidden as much as possible, which means in the backyard behind your house, generally speaking. And they allowed flagpoles, but limited to 16 feet, to be used as amateur radio antennas. They allowed wires, if they were fully within the owner's property, AWG 12 or smaller, non-reflective in color, and the leads, whatever that means, I think it means control wires and coax, had to be painted. Lightning arrest is required, and an annual inspection by the club is required. So the lesson to be taken away from Sun City Grand is rally your troops, and you might be able to get something that would otherwise not be available to you. The new book, Antenna Zoning, 3rd edition, came out this past July. It's being sold by the ARRL, DX Engineering, a few other places, and if you want a copy of it, see me in the hallway. We have a special price. It's $49.95 retail, and I'll give it to you for $40 cash out in the hallway. It contains some new stuff, talks about conservation easements, special privileges, getting prior approval, architectural control committees, dealing with height, and a bunch of new topics. About 25% of the text is new. This is what the cover looks like, and I wanted to finish up so that we'll have lots of time for your questions. We finish up at 45 minutes past the hour. And now, if there are questions on filing at the FCC, getting rid of your estate, or what you think the ARRL is doing for you in Washington, D.C., all of us would be happy to take your questions. Please go right ahead. You have to understand there's this gigantic fan here, so I can't hear a thing you're saying. As a result, I'm going to try to come down and get away from the fan. What you're saying.
Make it easy for you. If we have an FCC problem or we have a gripe and we want to get involved through, would it be easier to go through the ARL and have them represent us?
Well, the first thing you should be talking to is, you should be talking to your division director if you had something that you want brought up by the ARRL, and then your board will consider that matter, and then David receives his instructions from the board, not individual members. So please don't call him direct and ask him to act on your behalf. Besides, you can't afford it. The league pays his bills.
Yeah. But I will say that when something that the director believes should be brought up, he will bring it to my attention and ask, some advice on it. So that's really how it works.
No, you have to come to the microphone.
The first speaker mentioned something about negating the Karens or HOAs of the world through a federal law. I'd be very curious how that's going to work to negate all those covenants that we all signed.
So that's why God invented statutes.
If I understood the question, you asked how will the federal law deal with HOA covenants?
Correct.
The law is intended to override them. Private land use restrictions are created by state law. They grant the right to a developer or a builder to file of record all the restrictions, the color of the asphalt, the color of the pavement, everything. But they also include use restrictions. Some of those use restrictions used to say that none of you could fly a United States flag at your residence. Some religions require that the homeowners display certain religious symbols. Some of these restrictions used to say that if you were Irish, a different ethnicity, you weren't allowed in this neighborhood. It was called redlining. What happened to all those restrictions? They were written into those covenants that were filed as HOAs. They were created by law. Law took them away. Redlining is no longer legal. If you're Irish, Italian, you can live in these subdivisions now, regardless of what's filed of record. If your religion says, I need a religious symbol on my door, you can put it there. And to answer your question about Congress, cities and counties and HOAs used to say you couldn't fly an American flag. In 2005, Congress passed a bill called the Right to Display the American Flag. It's 2 paragraphs long. It states, no city, county, or residential association may prohibit you from flying the United States flag. What does that carry with it implied? It means you put up a flagpole. Anybody in the room have an idea what a flagpole can do besides fly a flag? To answer your question, all of these restrictions are permitted to be filed by law, a state law. That which government can create, it can remove. The Flag Act is one example of the federal government removing local restrictions. It can do that because it affects interstate commerce. This bill that we're filing directs the FCC to enact regulations to make effective the language in the bill. The FCC has absolute authority on all communications. They can override, under federal government authority, all these restrictions. So that's what we're intending to do. Again, it's a matter, that which the law can create, the law can take away. Did it? Okay.
Next question.
Just a general comment here. Along the lines of when the statement was, what do you do? Should you contact the league if there's, when should you contact the league to do something? I had the privilege of representing amateur radio in front of the American National Standards Institute, which set a standard, a cybersecurity standard for unmanned aircraft, drones. I called headquarters since I realized this is above my pay grade, and they directed me to the appropriate ARRL official, which in this case happened to be a division director. We worked together, and now in the ANSI standard, it is the way we want it. So the question, the statement, the direction would be, when in doubt, contact headquarters. They'll point you to the correct person to work with you to get the job done in favor of ham radio.
There's a guy at the league, his title is Regulatory Information Manager. That's the person you want to ask for.
Hi. A couple of years ago, the state of Montana legislature passed a law, a lot like PRB. It passed, with no opposition. Okay, so I'm about to go to the homeowners association, although written into my homeowner's contract is no antennas. And when I talk to the folks on the phone, they say, well, no ham antennas, you're out of luck, and so I wrangled into scheduling an in-face visit. But between what the state said and what the homeowners that I signed, where am I?
Okay, so the question is, there's a PRB1-like statute in Montana. Does it apply to a homeowner association? No. Which is why we are currently approaching the Congress of the United States for a law to override local homeowner association rules in this respect. But in addition to that, could try to organize the hams of Montana to get a Montana statute that would override a homeowner regulation. Or you can try the Sun City, Nevada approach that I just described to you, which is to just take you and any other hams that live in your condo association and lobby for a regulation that would allow things. Next question, please. Any other questions? Come on up.
I live in a condominium association, and I don't have an antenna. I'm not intending to put up an antenna. I operate by remote. When I moved into the condominium association, I entered into a contract where I signed an agreement to abide by the bylaws. How can Congress nullify an agreement, a contractual agreement between two private parties? I believe they either can't, or if they try, it will be overturned.
A good question, and by the way, a very common question, because it makes a lot of sense to ask that question. But the reason, and you've heard something about this before, is that let's go back to the 1930s, where you regularly found contractual provisions that would prevent a homeowner from selling his home to a Negro, an Italian, a Jew, a Spaniard, an Asian. And the Congress overrode those provisions of the homeowner association contractual agreements in the name of public policy. And that's the kind of thing that can happen again. Your homeowner association contract rights are not inviolable.
Will it stand up
And,
on
oh,
appeal,
would,
or will case law in effect overturn it as homeowners association?
excellent question. The heart of it is, if you were to attack an existing contractual arrangement seeking to put up an antenna with no intervening law, you're going to lose. If there's an intervening law which overturns the homeowner association agreement with respect to this very narrow point of law, it will succeed, and the amateur would then be allowed to put up an antenna despite the existence of what would then be an illegal homeowner association agreement. What? Oh, a great example. Bob Familio, K3RF, is pointing out that I have failed to mention that there's an existing example of exactly this situation called the Otard Rule, the over-the-air reception devices, which makes it legal for you, if you live in a condominium association, to have a home satellite TV reception dish, 1 meter or less, bigger in Alaska, VHF, UHF broadcast antenna for TV signals, and for wireless internet service provider reception and transmission. So there's an existing precedent for overriding homeowner association regulations with respect to antennas that have been upheld by the courts, and what we're talking about here is the possibility only that it would be extended from over-the-air reception devices, wireless internet service, and would then include amateur radio. Next question. Why isn't it happening yet is the question that's been put forward. The answer is it takes a long time to draft a really good statute that makes a lot of sense, and then you have a political process of soliciting members of Congress to introduce the bill. And we're in that process. Keep your eyes open this year. The bill that was previously in Congress, the man has asked what happened to the bill that was there. There was a previous bill in Congress which was, frankly, in my opinion as a lawyer, would have made hams worse off with the passage of the bill than had the bill passed. So the board of directors of the ARRL withdrew support for the bill, and it died. So the answer to the question of what happened, it died.
Let me explain. Fred and I are the authors of the current bill that's pending. To go further than what Fred said, the original bill that was before Congress was not written by anybody in this room. The HOAs wrote the bill. The people we had working on it gave up and let the HOAs write the bill. If you and I engage in a contract, and I write the contract, who do you think it's going to favor? There is an email that said from one of our people working on it to the HOA lobby, said, we gave you everything you asked for. What he was polite about, I'll be a little more blunt about. Had that bill passed, amateur radio would cease to exist in residential subdivisions in the United States. The bill was that bad. That's the reason the board, after looking at it with advice from attorneys all across the country, pulled the bill, requested Congress to withdraw it. We had one sponsor that was a ham. When the board made the decision to withdraw the bill, we talked to that amateur radio operator in Congress. We talked to all our sponsors and said, let's explain to you what you weren't told by the previous people working for us. By the way, the people working for us were fired because of what they did with this bill. When we explained why we were not happy with that draft, why we couldn't, the board wouldn't support it anymore, everyone in Congress said, fine, we're good with it. We'll back what you're going to do. And the same sponsors we had are still with us now. Yes, sir.
I was actually in the room that day with the senator when we explained to him why we wanted to withdraw support, and he understood the rationale. He, you know, it may come as news to you, but not every congressman and every senator knows every word of every bill, especially if they're 4,000 pages long and involve $4 billion. Thank you very much. The session ends at 45. We're now just about there. If anyone wants to talk to one of the lawyers that's been speaking to you today, we'll be right out in that corridor out there, and we'll try not to make too much noise for the next panel. Thank you very much, everybody.